Hi, everyone. I'm Greno, the Education Officer and Vice President of New South Wales AFI. Thank you for joining us for our April Education Night. I'm very pleased to have Priya Paquet from Hall & Wilcox presenting for us this evening. For those who don't know, Priya is an insurance lawyer, the more favourable type of solicitor, and she'll be examining a recent legal case study, the Challis case, which involved the destruction of physical evidence and its subsequent implications for potential litigation. Priya wants to take questions during the presentation, so everyone stay on mute. If you do want to ask a question, Priya is happy for you to chime in at the time. Without any further ado, I'll send it over to Priya. Thanks.
Thanks, Mark. Yes, I am happy to take questions only because it makes me feel like people are actually listening to what I'm saying. But with this case, what I would like to say before I actually get started is the case deals with 5 different forensic experts, all of whom I have used in the past and highly recommend. So the views that I put forward here are the views of the court and not my views. And just so no one hates me at the end of this seminar. So I just thought I'd get started on that. All right, so why is this relevant to you? And why is this particular case relevant to you? So as forensic experts, as forensic fire experts, you are really the first port of call for a fire claim. And that just goes without saying. The information you gather, it's valuable information for criminal investigations, for insurers, for claims and recoveries. So when the file or the claim actually gets to me, to a litigated phase, most of the time there's just no second chance for us to get the information that you are able to get. And this case really kind of demonstrates some of those issues. For example, with a recovery, I would usually have 6 years to issue proceedings from the date of the loss, but sometimes that can be 3 years. But it takes a fair bit of time to get to that recovery or litigation stage. And so it is really vital that we have the information early. And if we can retain that information early, that's what's going to ensure we have a successful recovery as well. So your actions can really impact on the outcome of a claim or the success of a recovery, really. So, and the idea behind this case is, while the court does go into a fair bit of analysis about the expert evidence, I think it also shows quite well the timeline of how things panned out, and it's interesting to see what happened in that respect as well. So, without any further delay, yes, please.
Sorry,
question?
just before you go on, just those timelines that you gave out, the 3 years, 6 years, is
Yes.
that state by state, or is that a Commonwealth statute style timings?
Look, it's pretty much across the board. So from a civil litigation perspective, which is where I'm involved, it depends on what your cause of action is. So, for example, if it's in negligence, you've got 6 years. If it's a manufacturing defect, in some instances where you are going to, say, plead the consumer law, that can be 3 years. So it actually depends on what you are seeking, of the basis on which you're seeking to sue the other party, if that makes sense.
Perfect, thank you.
No worries. All right, so Challis, and thank you for asking me a question, because it makes me feel like people are listening, especially with webinars. It's really hard to get that engagement. All right, with Challis, one of the things I just wanted to quickly touch on is the issue of subrogation. Now, most of you would know what that means, but I think it's important to explain it in this context as well. So most insurance policies contain a term that permits an insurer to recover from the wrongdoer using the insured's name. So when they pay out on a claim, they have a right to step into the shoes of the party who actually suffered the loss, and then seek that recovery from the wrongdoer. And that's what Challis really is the insurance companies that paid out the Challises are the ones who were running this recovery against Ford and Mackay City Autos. And that you'll be able to see that on the facts. So just quickly, just some of the brief facts. On the 17th of August 2017, the Challises purchased a new Ford Ranger from Mackay City Autos. About a month later, the Ford Ranger caught fire whilst parked in their garage, causing significant damage to the Ford and to their house. They argued, and when I say they, it's actually the insurers, they argued that the fire was a result of a defect in the Ford. And pursuant to the right of subrogation, their motor vehicle insurer, who was UE Insurance, and the home and contents insurer, who was a different insurer, being APIA, commenced two sets of proceedings on their behalf. One set of proceedings was for the value of the vehicle that was brought by UE against both Ford and Mackay City Autos. And the second set of proceedings was brought by APIA against just Ford. They didn't sue the dealership. After commencing the motor vehicle claim, the Ranger was disposed of by UE, and we'll go through the process in which they disposed of it before Ford could inspect it. Certain parts were also disposed of after notice of the claim was given to Ford. And then Ford and Mackay City Autos, they then said, well, in those circumstances, the claim that was being made was an abusive process and both proceedings should be stayed. And that's really what this case is about. This actual decision is about the court cross-examines all of the experts and makes a decision on whether Ford and Mackay City Autos are able to actually defend this claim because of the destruction of the evidence. So here I've just set out a bit of a timeline. This is kind of the key dates, really. So as I set out in the previous slide, in September 2017, the Ford caught fire. And it wasn't until March 2018, so we're talking 6 months later, UE issues a demand on Ford, including making a claim under the ACL for product defect. So there's potentially a 3-year limitation period there as well. And then on the 5th and the 10th of April, Ford writes back to UE solicitors and says, hey, we'd love to have not love to have an inspection. We would like to have an inspection of this vehicle to see what the cause of the damage is. On the 12th of April, UE then says to their expert, look, it's okay to dispose of some starter motor cables as storage fees were being applied every 6 months. Again, we'll come back to how they ended up making these decisions. On the 27th of June, UE provided photographs taken by their expert to Ford, but they gave no response on whether or not Ford could inspect the vehicle or any parts of it. It took them till the 29th of July, so we're talking 4 months later, to then write to Ford and say, you know, you can have an inspection can take place. You have 14 days to undertake the inspection. Ford doesn't actually then take them up on that offer. They just go silent. And then in November 2018 and January 2019, proceedings were commenced. The reason that there's 2 dates is because you'll recall there are 2 sets of proceedings. So they pleaded against Ford, who denied liability, and they put causation in issue. So they said the cause of the fire is unclear. February 2019, so proceedings have been commenced. And then after proceedings have been commenced against Ford, UE authorises the disposal of the entire vehicle for salvage pursuant to advice from their solicitors. So you can see here, straight off the bat, this has nothing to do with the experts per se, but on the advice of their solicitors, who said to UE actually went to the solicitor and said, look, we're incurring storage fees, etc. What should we do? And the solicitors said, oh, look, we've given them plenty of notice to inspect the vehicle. We told them they had 14 days. They didn't take us up. It's now 6 months, 7 months later. Our view is that we are coming with clean hands, so therefore no big deal. you can dispose of it. On the 9th of May, Ford then requests another inspection, and it's in response to that, UE's solicitors confirmed that the Ranger has been, so Ford didn't even know that they'd gotten rid of this vehicle until UE then responds to their request in May and confirms the Ranger had been disposed of, as there was no confirmation of Ford's desire to inspect. They said Ford had, did someone have a question? No, they said Ford had sufficient opportunity to inspect the vehicle, and the failure to inspect justified destruction given the cost of storage. And this is really what kicked off the proceedings, and this decision was the judge then having to decide on the evidence whether it would be unfair on Ford to have to defend this proceeding without the vehicle, or without inspecting the vehicle, I should say. So first, I'll just take you through these issues. These are the two main issues that the court dealt with, and then we'll come to the actual forensic evidence and chat through that, the interesting part, I guess, for you guys. But this is important. It kind of sets the tone for what the judge says about the evidence. In determining cause and a potential third party, so in terms of, say, any recovery, we've got to determine what the cause is and then who's responsible for it. And so in this particular instance, what the court said was the options on the pleadings or on the litigation and on the expert evidence are A, a manufacturing defect of some kind in the Ranger's electrical system. That's actually agreed between all the experts. Anyway, they all agreed it was an electrical malfunction, we'll say, or defect. B, it could have been a fault in the modification to the factory electrical system made by Mackay City Autos at the time of supply of the Ranger or after. So this is why they included Mackay City Autos in the proceedings, is because potentially it wasn't a manufacturing defect, it was an aftermarket installation. Or C, a fault in the modification of the electrical system by some other third party. So it might not have been Mackay City Autos or Ford. It could have been anybody who had installed some other aftermarket product. So those were the three potential causes of action and third parties that we were looking at. And then in discussing the requirement for an inspection, and I think this comes across through all the evidence, is where an expert, this is what the judge said, where an expert is confronted with the subtleties of the causation issues in this case, so the issues where is it an electrical fault, what exactly was that electrical fault, he said, I accept that it would be a significant potential advantage to determining the likely fault which caused the fire to be able to inspect the vehicle on an ongoing basis. This proposition was also not really disputed. So, and I think as forensic experts, I think all of you would agree that inspecting a vehicle or inspecting whatever the product might be would be of greater benefit than, say, looking at some photographs. So here's the fun part, I guess. There were 5 forensic experts that gave evidence and were cross-examined in this matter. The first one was, and I'm not naming any names, but obviously you can look at the actual case. The first one was retained by UE and examined the vehicle pretty early on and actually gave advice to UE to say, look, can't determine the exact cause. It is an electrical failure, but we're going to need to conduct a further inspection. And also there was a suggestion made that Ford be asked and be invited to inspect it straight off the bat, which obviously you didn't take the expert up on. Then there were 2 experts retained by APIA as well, who also agreed that it was an electrical fault somewhere in the engine bay. And they were the only 3 experts that examined the vehicle before it was disposed of. The difficulty that arose for those 3 experts, I think, when I read this decision, is that there were, and this only came out a bit later on, was that they were not instructed that a tow pack, and I know nothing about aftermarket installations in motor vehicles, so please forgive me if I'm referring to the wrong things, but that a toe pack and a 12-volt rear socket were installed, and they didn't note the presence and they didn't think to look for it, because when they spoke to the insureds, the actual Challises, they never mentioned any of these things, right? But then what came out in the actual affidavit evidence was that both Mr. and Mrs. Challis provided conflicting evidence on the modifications to the vehicle. And this, unfortunately, some of these things only come out in litigation. So during disclosure, it came out Mackay City Auto, so the dealer, had no records that the socket, etc., were not part of the sale and therefore were not installed at the time of delivery of this new vehicle. And the Challises gave deferring instructions to the experts, and the court said, you know, the timing, and it's pretty obvious on the evidence, I think, because everyone says it's an electrical fault, the aftermarket installation was a significant issue that needed to be dealt with. And the timing of that installation was also significant, because if it was installed at the time it was sold to the Challises, then Mackay City Auto was potentially the liable party. But if it was installed by, say, some other party in between the time they purchased and the fire, then that other third party was potentially liable as well. So based on the evidence, it was now very hard to tell who that third party might be. But this issue, just, we're thinking the fire occurred in 2017. This issue didn't come to light until April 2022, well after the vehicle was disposed of in 2019. So the poor forensic experts probably didn't, they just weren't given an opportunity to look at it. And then what the court then went into was obviously what each of those experts said. And then Ford put forward evidence that kind of, I'm going to say, muddied the waters a bit. So there was agreement between all of the experts that the fire was caused by an electrical fault, but they couldn't identify the precise cause. And they all agreed that inspection of the Ranger and samples was an important step to determine cause. Now, those issues that were unclear was what electrical fault caused the ignition and who was responsible for that fault, and whether the modifications could have been a potential cause. And without an inspection, none of the experts could agree on the precise cause and modifications. So I will take you to the next slide, which sets out the findings, and then I will talk you through the exact comments that the judge actually made about the experts, because I think that's really what's relevant about this case for the kind of work that you guys do. The destruction of the evidence at the end of the day is obviously key here as well, because none of the experts could review it. But the court ultimately stayed both proceedings. That means that no one, the Challises, neither UE, so UE's proceedings were stayed, but so were APS proceedings. Seems a bit unfair, but like I said, because of the subrogation issue, they all have to be brought together. Removal of batteries and disposal of the Ranger was found to be an abusive process. Central issue comes back to the cause of fire, and the court said there's no justifiable reason to dispose of the Ford. The July 2018 letter gave Ford 14 days notice, but what it didn't do was it didn't tell Ford what would happen if they didn't inspect the vehicle in 14 days. So I think to some extent, if UE had said, well, if you don't inspect the vehicle in 14 days, we will sell it for salvage, which they did for like $50, that then there might have been a different finding, maybe. But it was not sufficient to just give Ford an opportunity to inspect and say, oh, we gave them an opportunity to inspect between 2018 and 2019. And they also brought the argument that storage costs didn't justify them being able to keep the vehicle, but the court said that the court just threw that argument out and said that just doesn't justify the means, so to speak. And therefore the court said, oh, well, there can't be a fair trial simply because you don't know what the cause is. And if you don't know what the cause is, you don't know who the real third party is. And so the question of whether the electrical fault was caused by the factory system or aftermarket installation, who the relevant third party was. There was also a lost opportunity to discover evidence on the precise cause, and it was unfair on both Ford and Mackay City Autos to have to defend it on the basis that there was still this big question mark on what the precise cause was. So this is where I think there's a lot to be taken from what the judge said. Now, when you look at the reports that each of the experts provided, the 3 experts who looked at it beforehand, before disposal, we'll call it, and then there was another expert who prepared a report on behalf of Ford, and their report was very much based on photographs, etc., and suggested, look, yes, I agree, there's these parts here that look like it's an electrical fault, but it's hard to say whether it is an aftermarket installation, etc. So straight away, there's a question mark over the evidence. I see there's a question from David.
You can unmute yourself, David, and ask.
No. Okay. That's all right. We can take your question later. That's fine. Then because of the evidence from Ford's expert, Yui then brought in another expert to comment on electrical fault, and that expert said, yes, I agree, it is an electrical fault, but in cross-examination, he also agreed that it was difficult to comment on the precise cause of the electrical failure without, and he also said an inspection would be better because he also didn't have the opportunity to inspect. So we've got all these, but you would think that you've got 5 experts saying it's an electrical failure that occurred in the engine bay. That should be sufficient. But the difficulty here was at the very beginning, the 3 experts before the disposal, they all said, look, you probably need a bit more, another inspection and a bit more information, but that was never provided to them. And Yui went ahead and commenced proceedings. Now, obviously, when they went in, that very first time you go in to inspect, you're given some instructions, and that's what they have. That's what their report is based on. But what the court said was there was a lack of interest in the evidence of post-manufacturing wiring, and was only considered in response to Ford's expert. Now, you'll recall I was talking about the Challis is giving conflicting evidence. So I think, again, until the litigation occurred, no one had really obtained all of that or was able to obtain all of that information in relation to the 12-volt socket, rear socket, and a toe pack. So that became a real issue in the proceedings. And then what he said was the focus on one particular aspect may have informed the approach to inspection and decisions on what to photograph as well. So one of the things what he's saying here is it's almost like a bias. What he says is, because there was all this focus on, it's a new vehicle. Understandably, it's a new vehicle, so everyone is focused on why would a new vehicle that has just been brought home, about a month and a half later, catches fire while turned off. Everyone's quite focused on that, and his view is there weren't the photographs that were taken. As a result, were very focused on what everyone else was focused on, because there was no information on the aftermarket installation at the time when those forensic experts inspected and prepared their reports. He was not satisfied that nothing could be obtained from the Ranger or its parts because the after-manufacture circuit breakers were identifiable and debris said, oh, there was nothing left of it, so it's not like the forensic expert would have been able to tell. But again, the difficulty here, it comes back to the same issue, is that there's no precise cause. But also, I think as forensic experts, I think you'd all agree with me that no matter how large the fire is, there is something you can find in there. You know, I come across recoveries constantly where I have one that's like probably worth about $3 million. And when the insurance company went in with the loss adjusters, they didn't, they looked at it and went, oh, it looks like it was the lithium battery, some lithium ion battery, but nobody retained it. And no forensic expert looked at it. So I've had to advise the client, say, look, even if you did have a good recovery, we've lost an opportunity here because you've just destroyed all the evidence. So, you know, and that I think is key, and probably more so when it comes to you guys inspecting the evidence, important for you to also consider, okay, do I need to be informing the client, being the insurer or whoever it is that's instructing you, that, you know, all of these things need to be retained. And then obviously we touched on earlier the emergence of the potential cause being the 12-volt socket or the aftermarket installation. There were no instructions provided to the experts. So even when, and I think part of this was when UE realised from the Challises, when they obtained the evidence from the Challises, that should have really have been put to the experts because in looking at their initial reports, and this is quite a common theme, when you first look at something, you can't make a final conclusion straight away. You probably need to do more investigations. And that additional information was never provided to the experts to comment on in order to make the determination that, okay, yes, it was an electrical failure in the engine bay, but it could have been X or it could have been Y. So that opportunity was never there. And then he made this comment about the inadequacy of photographic evidence generally. I thought this was an interesting point to raise because he said it's not a complete record, right? Now, obviously, if there's a total loss fire and everything burns down, you can't actually retain anything. You take photographs and all that kind of thing. But I think what he's actually getting at here is he's saying, well, it's two-dimensional. It's not sufficient. So I question whether maybe, you know, video evidence might start to be more relevant, you know, whether it's with a phone or whatever it is, whether that might be more relevant. But I just thought I'd throw that comment in there because it is interesting to note, because even when I deal with expert reports, it's the photographs that we rely on. So yeah, that's just something to think about, I guess, moving forward. And then finally, what he said was, none of the experts express an opinion as to the specific fault or mechanism which caused the initial ignition of fire. There was criticism that the explanation fails to grapple with causation issues in the proceedings. And again, I think this comes back more to report writing than the initial inspection. I think what we take from that particular point that the judge raises is it's really important to be clear, to set out your methodology and how you then achieve that. And if there are further investigations that are required, that you clearly state that. I think to the extent where you actually put in a little heading that says further investigations required and set out what that is, I think that would probably help you as an expert when it comes to cross-examination and things like that, to actually set out what further evidence you are going to need to review in order to provide a conclusive opinion. In any event, he actually, I think it was an easy decision for him to make in this instance, but he preferred Ford's expert on the basis that he considered what could have been productively done to interrogate the remains of the Ranger. So what Ford's expert did was that he went in through this whole methodology that he would have followed. I'm not saying it's right or wrong, and I'm sure there's experts in this particular forum that might disagree. But he went through specifically, okay, this is the methodology, this is the line of inquiry I would have followed, etc. Whereas and understandably, the other experts didn't have that process set out, but that's simply because they had actually inspected the vehicle, in my humble opinion. Whereas Ford's expert was brought into the proceedings to actually throw mud at the wall, to muddy the waters, so to speak. So I think, him setting up the methodology, very good, but also it helps Ford's case even more because of that.
Hey, Priya, could I chime in just quickly?
Yes, please do, Mark.
One of the experts did
Yes.
know that there was an auxiliary circuit connected. One of the experts did recommend that the vehicle needed. The issue was with the vehicle was it was in a garage, and the roof had collapsed on top of it, and digging it out there was a bit problematic. Like I said, one of the experts did work out it was an auxiliary circuit. He was told by the Challises that all the aftermarket components were installed on the vehicle by the dealership. And that expert recommended that the vehicle be towed out of the garage and then taken to a mechanical workshop so it could be elevated on a platform so that the auxiliary circuits could be inspected. And that never happened for that expert, that particular expert. The other experts did look at the vehicle again, and yeah, the outcome is what happened.
And remove some things, yes.
Well,
yes,
sorry. The other expert removed the items before.
Yes.
The expert I'm talking about looked at the vehicle, which shouldn't have occurred either. So yes, carry on, please.
Yes, and that's right. That's exactly right. The initial expert did say further inspection was required, etc. Made that very clear, actually. So, but it was, and that's why I think it was UE that missed that, or their solicitors that missed that point, that they were going to need some further evidence to prove cause or causation. And then the other two experts the other expert that looked at it did remove some cables. I'm going to call it cables. Obviously, my technical knowledge is limited.
It was a starter motor cable.
So that's it. And with those particular ones, they were also destroyed on instruction. So, so as a result, no one could even inspect those samples. So, yeah. He was actually critical of one of the experts as well, on the basis that that particular expert that did, if I was to, in reading the decision, the judge was actually quite complimentary of the initial expert and Ford's expert. He did make some comments about APIA's experts, and said that, and I think this is a good takeaway actually, from what the judge said, was that particular expert for APIA was quite defensive in cross-examination, and the suggestion in the decision is that he was starting to come across more like an advocate than an independent expert. And so that's just another little takeaway, I think, from that one. All right. So what can we take away from all of the comments and criticisms, etc., is, in terms of your inspections, your first one, I think it's important to not just rely on the instruction from your instructor. It's important. And I think, so I actually ran this particular seminar with your Queensland Association. And one of the things they had talked about before I did my presentation on this case was they had already talked about report writing and bias amongst themselves. And I thought that was really interesting, and it was a really good segue into this case, because one of the things we're talking about is, like, you can walk into an inspection and already have a bias for certain things. Go, oh, I already know what's caused this, or I've seen this type of fire before, or And there's different types of biases, obviously, but it's just being conscious of that bias and knowing that you might have it will enable you to take a wider view, I think. And that comes back to the photographs, right? The comment he made about the photographs is he said, well, the experts were looking at it from a certain angle, I'll say angle, but from a certain perspective, and therefore their photographs weren't necessarily complete, is how he ended up finding, or the criticism that he made. So in order to avoid that, I think it is important to go in with a clear mind. And I think we all think that we do that, but it's really important to be conscious that we might not be doing that too. Report writing, I think this is a really important one, because the comment about the methodology was a really good point to take out of Challis, because when you do this day in, day out, which you do, this is your bread and butter and you're the experts in this area. I'm the layperson that's reading the report, and I honestly just go to the conclusion first. But what helps the court and the expert, coming back to the expert code of conduct as well, is to understand how you reached your conclusions. Now, a lot of people will say, well, I did put my methodology in. I always put my methodology in. I say, I obtained this particular item, I inspected it, etc., etc. But what the court is really looking for is the step-by-step process, your process that you've undertaken, that if you had to go back, you'd be able to do that process again in coming to that conclusion. That is what they're after. So just something to bear in mind. And the biggest thing from this case at the end of the day is, and my view is the solicitors probably missed the point too, is that there was no precise cause of electrical failure in any of the 3 expert reports that had been obtained prior to disposal. There simply wasn't. As Mark just mentioned, they had all indicated that further inspection was required and certain other things had to happen, etc. But that wasn't identified. So I think from a report writing perspective, it's good to highlight that in your conclusion, is that, and to even say it, cannot form a conclusion on the precise cause. It is likely X cause, but until these steps are undertaken, we will not be able to do that. We've already touched on photographs and examination. And also really important to foreshadow potential litigation, because from any point of view, there's always an insurer involved when there's a fire. There's going to be a recovery, or hopefully a recovery. And, if you are looking at it from the potential for this matter to be litigated, then again, it comes back to, you're more likely to think about, okay, what's the court going to want to see? And we've got the expert code of conduct that sits in the Uniform Civil Procedure Rules that needs to be followed. But basically what that code says is the expert needs to explain in plain English how they arrived at their conclusion, their methodology, the investigations they undertook, and their conclusion. And don't be afraid to put something in there about if further evidence comes to light, my opinion may change. This opinion is based on the evidence available to me, etc. And I think that's important, because one of the things the court actually said was, when about the particular expert that the judge was critical of, was that they weren't prepared to move away from their opinion when kind of questioned about certain things. But it is okay to change your opinion, because different things happen, right? Like, for example, had the expert been able to examine the cables, we'll call them, then something else would have happened, would have flown from there. But that didn't happen. So it's okay, but that expert would probably have changed their opinion had they been able to do that, right? So it's okay to put that in your report as well, I think, and I think important moving forward to do that, and be open to changing your your opinion when other things come to light. So I just thought I'd touch on giving evidence, whether it's in report writing or generally. It's important, obviously cause of damage, obviously most important thing. Inspections are important. Was it a product? And because from that, based on your inspections and investigations, is how we as lawyers can determine who the potential third party might be. So you need to be as specific as possible. In terms of your opinion, test your assumptions. Really important. Is this right or is that not right? Now, that feels a little bit like preaching to the converted when I say that, obviously. So I appreciate that everyone does do that. And keep it simple and unambiguous. The simpler it is, the easier it is for the court. And one of the things I even say this to my lawyers is, the simpler an affidavit is, etc., it means that the judge is going to be able to read it easily and it makes them happier. So they're more likely to accept it. And be prepared, like I just said, be prepared to change your opinion. It is okay to change your opinion based on evidence and facts, etc. Set out expertise and methodology, and just something to keep in mind is privilege. Question whether, if lawyers, if lawyers are appointed, it's really important to ensure that you're just sending your report and in Queensland, it's a bit different, but in New South Wales, all of your correspondence is actually privileged with the lawyer, but it's different in Queensland. In Queensland, anything you send me in writing is not privileged. So important to just do a verbal first before you put anything in writing. I don't know why Queensland's always wants to be different. And then physical evidence. I'm just trying to take my time. We're going okay for time. Physical evidence. Retain physical evidence, please. Photographs, I think, and I've put in their videos simply because of the comment from the judge in Challis. I think taking a video I think photos still have a place and are important, but I think it is good to have videos as well, just to ensure that we are covering everything. The other thing also is notes of your discussions with people. So whether it's an insured, another witness, really important to keep those types of notes. They will end up being discoverable, but I think it'll support your findings in terms of whether it's cause, and if somebody was to say to you, well, actually that's not really what happened, this is what happened, you can go back and we can prove that this is what this particular witness said, what they saw at the time. That's really helpful as well, I think, in terms of providing your opinion. That actually brings me to the end of the presentation. Does anyone have any questions they would like to ask? I will stop sharing so that we can actually see each other.
Priya, I have some questions for you, if that's okay.
Of course.
So you've got a mix of public versus private investigators here, and obviously us public guys, we're really fortunate. We get to see the scene pretty much as the incident happens, or as it's happening, or relatively afterwards. I suppose the issue that the private guys face here, and I think I saw Jim Monday in here and Mark's here as well, and stuff, but how often do these guys, or how often do you see from a layman's perspective or the legal perspective, these sorts of issues happening in the industry?
Surprisingly too much. And it's not really because I think a lot of forensic experts think Challis is a real is the court having a go at the forensic experts, but it's actually not. It's actually the court having a go at just simply someone deciding that they can destroy the evidence. What I find is and 2 points there, actually. From the first responder perspective, you guys have a job to do. And sometimes the evidence can get a little bit destroyed, so to speak. And there's nothing we can do about that. But what we can do, when the forensic comes in, if they're able to rely on your report as well, then we're okay. The other flip side is what we're finding is from a civil litigation perspective is what I think I used an example is insurers not understanding or for other, like from a civil perspective, large loss fire, everyone goes in and the response is, oh, there's no evidence here, everything's been burnt. Right? So there's a little bit, and I would have thought we've come so far over the years with appointing forensic experts that people would realize that that doesn't matter. Only a forensic expert can make that decision. And that's the decision. I think that's the difficulty we're having is I've had the comment where an adjuster said to me, oh, the fire burned so hot, there was nothing left. So we just got rid of it. And I went, okay, what's your expertise? You know, he goes, oh, there's no way you could have been able to tell cause. So that's really what I'm finding is the destruction even before we even get to the stage that Challis got to. Challis, I think, is an anomaly. I'm going to be completely frank and say I think the solicitors really are the ones who should be on the hook for giving the giving the advice to UE that they were okay to destroy it. I'm going to say that openly. But yes, I hope that answered your question. Peter.
Oh, sorry.
Yeah. Hi, thank you. That was a very interesting talk and very relevant. I'm a person that spent a lot of time in the university environment and then a lot of time in industry. And my background was hard research into fire causes, Ash Wednesday, things like that. And I've subsequently moved through to helping the coroner and police and fire and rescue and so on. What I found is that the depth at which we would have had at the University of Sydney, for example, in absolutely understanding the fundamental mechanisms of fires and so on, don't really find themselves way into reports. And one of the things which my boss used to say to me all the time when I was at the university is there's a distinction between possibility and probability and so on. So when I write reports, what I tend to do is list the facts as I see them and often rely on people with much greater forensic skills than mine, their reports. And so what I do is try and collect all the facts and then simply say in another chapter, this is how you may interpret those facts. So there could be a number of interpretation of the facts that are available. Now, I've not had any feedback from anyone about whether that's a good approach or a useful approach. My second point is, when I work with lawyers, which I've started to do a bit more, including in car fires and things like that,
I'm sorry to hear that. Yeah.
In my space, it's almost impossible to know what lawyers want. They can take a year, and you could go through and you can say, but I think you should do this and this, get this analysed and stuff like that. And a year will go by, and even when there's deaths involved, the police mightn't contact you for 6 months. And the evidence, you have to rely totally on what other people have recorded. So what I do is I use reports where what the point that I was trying to make is there are people that are really good at collecting site information, but useless at interpreting it. So, you know, they can actually do really good photographs and things like that, but they don't have the skill set to actually often to interpret that. So does the legal system cater for that there are subsets of skills within the community of people that inform the cases? Sorry, I could talk for ages on this. You've opened up a lot of doors.
Good. Doors, questions, I don't know, holes. Look, Peter, I think, yes, the key, I think, if I was to distill your question, is to stick to your expertise. Right. So if there is somebody who, you know, I have one with Jim actually, and you know, somebody can collect, you know, you take a deliberately lit fire, for example, and you'll collect the samples, but the forensic expert that actually collects the samples can't actually test those samples. It's somebody else that has to test those samples, and then the forensic expert will then rely on those samples. And as long as you are saying that in your report, that is okay, because you are then relying. And then as lawyers, we are the ones that have to call evidence from both the people that tested the samples and came up with the results, as well as the forensic expert. So as lawyers, that's what we should be doing. The other part of your question was, I think, to do with setting out somebody else taking the evidence. No, I think I answered that part. Does that answer your question, Peter? I think it does, but I'm not sure.
Sorry, yes, it does in a way, but the sense that I get when you were speaking is that each expert has to come up with a definitive answer. Can't an expert simply say, I'm an expert in collecting data, someone else can, because I never would say when I'm with the firefighter, they know what they're talking about. And so my basis is, if they say this is the origin of the fire and stuff like that, it's usually pretty good. So do you make that distinction from your angle, or do you want an expert to actually say, this is my interpretation of or my opinion as to where the cause comes from? Sorry.
So if that is your expertise, if I retain somebody to tell me what the cause of the fire is, it'd be based on their expertise. So for example, if it's an electrical fire, once you get in both the fire forensic and the electrical expert, because they have different skill sets. And together, I would like to think we can come up with the cause, right? If you are not able, on your own expertise or the evidence that you have available to you, I think it's really important to say, I can tell it originates here, but I cannot tell what the precise cause is, or I need further evidence from XYZ in order to comment on the precise cause. Look, actually, you've raised a really good point in that with Challis, I think, if in the perfect world, that first expert would have got the inspection of the cables, that we would have made that happen. And then they could have prepared a report on that basis, right? And then we would have been able to, the solicitors or the experts would have been able to go, actually, look, unclear whether it's aftermarket or whether it's the factory factory systems, unclear. And then they would have just joined both parties and could have run it in that way, right? And then if the actual evidence was still available, Ford would have had an opportunity to come in. Now, what the court was left with in this particular situation was 2 or 3 experts saying, we know it's an electrical fire, and we know the area in the engine bay, but we do need to have another inspection. Therefore, there is no precise cause. Now, my view is, if one of those experts were able to give a precise cause once they had this additional inspection and got all the evidence, right, then even if the vehicle had been salvaged and was no longer available, I think they would have been able to run this case against Ford. Does that help you answer your question?
It does. I see there's another hand up, but I have a question related to that. I'll ask after, if you don't mind, after that.
No.
Is it Darren? I can't read the...
There's Jim, I think, has had his hand up twice. So I'll go to Jim and then I'll come to you, Darren.
Thanks. Hi, Priya. I'll try and keep them quick. 3 things. The first thing is about the imaging, and you're quite right. Photography can be a problem because it's 2-dimensional, and I make a point of putting that in my reports if I'm relying on somebody else's photographs. So I say, that it's not always the best way of seeing a scene. As well as video that you've mentioned, I think modern iPhones, LiDAR 3D scanning capabilities now on iPhones and things like that, and iPads and so on, if you've got the latest versions. So they're becoming much more available. The problem is putting that with a report, because it requires the court to not only be able to report, but to have a screen that they can watch your 3D animation on as it turns around. So that's one issue. Second thing, we are reliant as experts, we are reliant not only on instructions from the insurers, but on feedback from the insurers. Now, if I send a report to an insurer and it says, at this stage, I can't tell you what the cause of the fire is, but it needs this, this, and this done. I don't then hear from that insurer for a year. I don't know whether they've settled the claim, paid the claim, whether they've got litigation ongoing, whether they're waiting for something else to happen. I don't know what they've done with if it's something like a car, I can't retain a car in my workshop, in my lab. I haven't got room,
It's a great point.
We've got, you probably know this, we've got a warehouse, it's a massive warehouse, but it's a big enough warehouse. If we kept every washing machine, dishwasher, etc., that we take from fire scenes to establish the cause, and just held them there until the insurers tell us that they've finished with that claim, we'd run out of room in 6 months. Okay, which is why most companies have this 6-month retention policy. So what you do is you go to the insurers after 6 months and you say, do you need us to keep this? And if they say no, off it goes. Now, we've got to do something. What do we do otherwise? We take over an airfield somewhere and fill it with scrap, So that's another issue. So we're not relying on the solicitors, we're relying on the insurers to tell us what to do. They're our clients initially. The third thing, very briefly, is that you touched on a job involving a lithium battery. The problem we've got at the moment is that there is no safe, approved method for retrieving and retaining damaged lithium batteries. We have no way of doing it safely. Now, people are working on that, but there's no approved method at the moment. So at the moment, our policy is we record it, we photograph it, we do everything we can in situ, and then we try to keep it in a safe location at the fire scene so that if anybody else wants to go and look at it, they can go and look at it.
Yeah.
But I'm not bringing it back to my workshop because I don't want my workshop burning down in the middle of the night.
Yeah. Yeah, no, I appreciate that. And I do appreciate that it's insurers that are giving you their instructions. I think it's important there's only so much you guys can do in that sense. But I think one of the things that you could probably do, I think, moving forward, simply because of the this case, I guess, because everyone seems to be really focused on it at the moment, and things move on usually, but is to mention, I think, to the insurer, do you want us to retain this for the purposes of a recovery? Because the reason I say that is, like you said, it's not me necessarily, and I said that at the start. I don't necessarily see the claim until it's probably 4 years down the track, right? Unless I'm involved in the actual claim side of it. But for an insurer, a claims officer who doesn't necessarily come across this type of issue on a daily basis, they're not thinking about it. But the second they see something like that, it's got a tweak in their mind too. But I completely agree that you shouldn't have to store it if they're not really telling you what's happening. But it's important you give them notice. And then to take from this case, I think it's important to give them notice as to what would happen if you don't hear from them. Yeah.
Can I just add something to that? Just to add something. Obviously, I worked by myself, but when I did work for a company, I was watching one of my exhibits walk out the door, about to be thrown into the bin, and I'm like, well, what's going on here? Because I knew that was part of a recovery. So I think the onus is on the investigator as well. Because obviously, like Jim says, 6 months, you write an email, a claims handler gets it and goes, yeah, throw it out. They don't know anything about the recovery. They're a claims handler. It's gone to the recoveries teams. It's gone to a solicitor. That claim handler has no idea what's going on with that. And then I got a procedure changed that no exhibits get disposed of without the investigator's approval, because most investigators will know if their exhibit is part of a recovery or if it should be part of a recovery. So yeah, but there's obviously issues with that and evidence, and then it going with solicitors, and then the elbow not talking to the arm, and that sort of stuff. Yeah, thought I'd just give you that insight.
Yeah, that's a really great idea, actually. You know, because you guys are the ones at the forefront who've gone, oh, it's probably this and it's probably these guys. So, yeah, that's fair that it gets run past you first. Yeah. Darren, I think you had a question.
Yeah, just great presentation. Just a quick one. That chain of evidence.
I can't hear the.
I can't hear you, Darren.
You have to
We
talk
can't
into the
hear you.
microphone.
It's not coming through.
Just try and work on it, Darren. I think, Peter, if you're ready to ask your second question.
So should I ask my question?
Yeah.
Okay, if you're looking at something like your vehicle and you know something about coordination of circuit protection and the way things should be installed, if a third party subsequently puts something on which is incorrect, but the protection which exists within the vehicle, such as fuses and circuit breakers, should have protected it anyway, do you actually need to go beyond that? Could you simply, as an informed person, say, if your system's built correctly, then what you add on to it shouldn't have any impact at all? So you don't need to actually find the cause. You just have to, in a very general way, say, you're responsible for building a system which was not tolerant to these kinds of things.
Well, that is your cause, though, isn't it?
Well,
so
why wasn't that point put forward?
That
Do you want me
is
to
a
answer this
good
one, Priya?
question. Yes, please.
Okay, so with that matter, right? If you've got two parties, you've got Ford, who manufactured the vehicle, and then you've got the dealership that added something to the vehicle, right? Knowing a little bit about this case, no amount of electrical examination was going to identify the electrical cause. Any amount of arcing, or sorry, not arcing, any amount of melting to any conductor in that vehicle could not be conclusively determined to be an electrical arc or just melting due to heat exposure. The auxiliary circuit was fused, or it did have a circuit breaker. So who are you going after? Is it Ford's fault, or is it the guy that installed the aftermarket accessory? See, if this matter was done correctly, it would have been established. Everyone would have had a chance to look at the exhibits or the evidence and say, yeah, we can't work this out. And then it would have been up to Ford and the dealership to front up probably 50% of the cost each. But because the evidence was lost, the judge decided, oh, well, everyone loses. Well, not Ford, but yeah, so that, yeah.
Yeah. And that's the risk they ran, Mark, because the solicitors, if they'd read the reports properly, would have gone, okay, there's no precise cause, so we should really keep the vehicle. Yeah. So that somebody else can also say that, and then it is lines are blurred, and then parties will talk.
At least it's done. So everyone had an opportunity to work out that we aren't going to work it out. And I think the lawyers made an assumption that was good enough. And then they didn't give the other side the opportunity, and lo and behold, this was the outcome, unfortunately for them. I think David's got a question. David?
Yeah, I think Angus has had his hand up too. Yeah. Sorry, David, yeah.
Oh, thank you very much. First of all, it's been a wonderful presentation. You've made what potentially could have been a very dull subject quite interesting. So thank you for that.
Oh, good. I'm glad to hear that.
Now I've done the nice bit, I can get on with being devil's advocate. I'm with the RFS and we do a lot of bushfires. situation where we have a large branch falling across a power lines that's cause a bushfire and then goes on to cause significant damage. How would we go about storing power lines / branches to meet the forensic requirements of that?
So I literally was having this conversation today with somebody. One of my partners here, he ran, I don't know if you've heard about the Parkerville bushfire class action in Western Australia. It went to the High Court. And basically how the bushfire started was a power pole was rotted and fell and ended up causing this bushfire. They actually had the piece from where it broke off was retained. So based on the evidence that was obtained from the expert at the time, they knew what section of the pole to retain, and that was retained. So if you can, you retain it. But look, a massive power pole like that, I think the court would accept that photographs and a video potentially would be sufficient to get you over the line, because yes, it is such a large piece of evidence that it would be impractical to actually retain it. They, on the other hand, in Parkerville, they just retained the bit that was, they say, was rotted. So they were able to prove what they said was the cause, the rot. They were able to prove that and actually had it in the courtroom so that the experts could all point to bits. So I hope that answers your question.
Sometimes you have to hire a shed and store it. That's what you have to do.
Yeah, and the insurer's got to pay for it. Yeah.
Yeah. Which Peter wants to? There's two Peters with their hands up. We'll go with Peter Mansourian first.
Yeah, thanks for that. Can you hear me?
Yep.
Yes.
Okay. Look, in my opinion, size shouldn't matter. If you're looking for facts, truth, evidence, and all of that sort of thing, why should size matter? I've had jobs where I've told the lawyers to hold in storage large harvesting equipment, all sorts of things. So sorry, I've got a kid in the background here. A person either wants the truth, fact finding, or just convenience. I mean, people got to be serious about what they're doing, I think. I'll leave it there. Thanks.
No, that's fair.
The other Peter?
Yeah.
The other Peter, who would be? I've been involved in a lot of cases with police, fire brigades, and lawyers and so on. Every piece of evidence that I can think of is destroyed as soon as it can be, you know, including large harvesters and things like that. Who would you say should be? And I have no say. I mean, if I talk to a lawyer, it's sort of infrequent. They just give you an instruction. Can you do this? What's the cost? It's not a fluid sort of two-way conversation. It's just a one-way direction. But anyway, at the end of the day, who do you think should be responsible for saying, hey, guys, you've got to keep this? And who is it that keeps it? I mean, who bears the cost of doing that?
Firstly, you know, not all lawyers are the same, Peter. No, look, I think in terms of the cost, it's the party that is seeking to prove something, that needs that evidence to prove something. So in this particular instance in Challis, it was the two insurers that should have been bearing the costs of retaining, storing the evidence. In terms of whose responsibility, I think we've all got to take a bit of responsibility. From an expert's perspective, if you've identified something that, you know, your report says, look, I think it's XYZ, I think it's this person or this entity that manufactured something, then it is important that you alert your instructor, whether it's the insurer or the lawyer, etc., that you think that is an important piece of information that should be retained. then it is up to the insurer also to go, okay, well, an expert has actually informed me that there's a potential recovery on this based on the report and based on what they've just said, look, there's a potential recovery here. I mean, it's not up to you to comment on a recovery per se, but it is important for you to say, this would be important evidence to establish cause or something like that. Or prove who the third party might be. And then there's a bit of responsibility there on that claims officer or whoever it might be to then pick up on that point and go, okay, it's really important. And then also the lawyer, from the lawyer's perspective, for us to go, well, hang on a second, if I'm going to run this litigation, I'm going to want that piece of evidence for the other party to look at, but also if other questions come up, I want my own expert to be able to respond to those questions. So I think there's a little bit of responsibility to all the parties involved, Peter.
Thank you. I've got writer's cramp writing all that down, so it's been very useful. Thank you.
I believe this session is being recorded, so.
Oh, is it? So can we get a copy of that?
It'll be on the website.
Okay.
Yeah. Angus, did you have a question?
I do indeed. Firstly, thank you, Priya. Thank you so much. This has been fantastic. I've never seen so many questions asked after a presentation in a long time. But going back to our report writing and photos and videos and stuff like that, obviously this case occurred back in 2019 where tech is where it is now. Certainly, I encourage my guys, if they do take videos, to grab screen grabs and things like that out of them, just to demonstrate that there is a video and say the whole video is available upon request. Because certainly as public investigator, or for any investigator really, we certainly we can't take that 3D option and produce it in a 2D report. I suppose my question to you then is, are you seeing more prevalence of walkthrough videos through the use of LiDAR and it being reproduced in the courts?
Not yet, I don't think. To come back to your point about you can't put a 3D video into a 2D report, I think it's important to just keep it, at least, even if it's not about it being in your report. I think if it's possible to go back to it, that is better evidence. Say, let's take Challis as the example. Say, yes, okay, it was destroyed, but there was for some reason some video, let's just say, then I think it would have been harder for Ford to run the argument that everything was destroyed, because there would be this ability. But obviously, again, as Mark pointed out, they didn't even get the opportunity, the experts didn't get the opportunity to even inspect the bottom of, the auxiliary cables. So that video would never have been provided, but on the assumption that, let's just say, there was all of that video evidence and then the vehicle had been destroyed, I think Ford would have had a much harder case to run. So it's not a case of it having been in the report per se, but I am seeing, not necessarily from a forensic perspective, but yes, video evidence is definitely more prevalent in general, because that's just now the mean. So, the courts have screens, etc., that they're happy to put it up on. Even our court files, when we tender documents, it's all electronic now. So the capability is there. And I would think that's where we are moving towards, as opposed to just a set of photographs.
Thank you.
Yeah.
Did you have another question, Peter? Or was that no? I think that's it.
Peter,
Thanks,
pleasure.
We've run over time a little bit, but
that's okay.
Thanks for everything.
Pleasure. It was a real pleasure. Thank you all for your questions. I actually really appreciate it. And if you do have any questions, please feel free to contact me. I have absolutely no problems with that. I'm happy to pass on the slides to Mark, and if you want to circulate, if anybody wants them.
Yeah, we'll post up the video, so yeah, people can watch it again if necessary. Yeah, thanks a lot, Priya, for joining us this evening in that presentation. And yeah, it was interesting, especially for me. And just want to remind everyone, or if anyone doesn't look, we're down a few because people have gone overseas to America for the ITC International Training Conference. I was going to wish them well, but I think they've already left because it's next week. So yeah, all right. Well, appreciate everyone for showing up tonight. It was a good presentation. Thanks, Priya, again, and
Thank you
see you on
all.
the next one. Thank you.
Thank you very much, Priya.
Yeah, good work.